We are providing sidewalk service, so if you would like to borrow materials, whether they're books, magazines, movies, you can do so simply by searching our catalog on our website, which is www.monterey.org/library, and then place a hold on materials that you would like to check out. And once you get an email or a snail mail from us, depending on your preference, then you can come and pick up your materials Tuesdays through Saturdays from 11 to 6. If you don't have a library card with us or with the Pacific Grove Library, or what I've just explained doesn't really make sense to you, you're always welcome to call us and ask, and we can help you put things on hold. Our phone number is 831-646-3933. And we are answering the phones Mondays through Fridays from 10 to 6 p.m. If you don't reach us in person, simply leave us a message and we'll be happy to return your call. We have a number of adult programs coming up, and you can find the list on our website. I did want to highlight one program that's coming up next week, and that is on Wednesday, August 26th, from 6:30 to 8 p.m. to celebrate Women's Equality Day. It was the day that the 19th Amendment was certified, and it's a history talk with Dennis Marr. Now, 9 years before the ratification of the 19th Amendment, California women achieved full voting rights through an amendment to the state constitution. Dennis Marr used our California History Room. He used digital newspaper files and other historic resources to research the movement, the suffragist movement here in our area, and he's going to share wealth of knowledge that he's learned about that. So I also wanted to give you a little teaser too. The novel by Steinbeck, Cannery Row, is turning 75 this year. So look at our website. In September, we're going to have book discussions. In October, we hope to have some film screenings. And then in November, we're going to have a panel discussion all about Cannery Row. And that's made possible through the support of our friends and foundation. They help us purchase materials and offer programs, and they have a brand new website I wanted to share with you. It is www.investinmpl, for Monterey Public Library, .org. So that's some exciting things that are coming up. But what I'm really excited about tonight is welcoming Eric Holk. Eric has practiced law here for 30 years as a certified specialist in estate planning, trust, and probate law. Eric is a native Californian who studied history as an undergraduate, and then he went on to earn a master's in counseling from Fuller Seminary in Houston, Texas, a JD from the Monterey College of Law, and an advanced designation as a chartered financial consultant from the American College of Financial Services in Bryn Mawr, Pennsylvania. Prior to starting his own law practice, Eric was a counselor at Hartnell College. So I hope you're getting the sense that he's a very patient, kind, and knowledgeable estate attorney. He has been a lifelong learner in history, philosophy, religion, and science. He has been active in charitable programs and has been a speaker on estate planning and probate matters for many local and national organizations. And Eric and his wife live in Pacific Grove. They have 2 grown sons and 2 cats. And if I'm not mistaken, I think he and I both enjoy something which is working on jigsaw puzzles when the cats don't eat the pieces. So please join me in welcoming Eric. Thank you.
Thank you, Inga. I'm happy to have you here with us tonight. And we're going to try and cover a lot of ground. So I hope you have your pre-printed handout materials ready to refer to as we go, because I'm going to be referring to that. And if you don't have that, that's okay. We'll get you a copy later. But for now, we're just going to follow along with that particular handout. And so here we go. All right. First question I'm going to address for you is, do you have a will or a living trust? Everybody really should have a will or a revocable living trust. If you don't, now's a good time to get one. You know, don't wait until you're on death's doorstep, because that's not when you want to be doing this. And your will or your trust should be current. There's a lot that has changed in recent years. I'm going to hit just some bullet points that I want to bring to your attention, the things that I see most often as problems for people. The first one is your named executor or successor trustee still living? And is that person still willing and able to serve? If not, or if you're not sure, ask. That's something that's extremely important. A lot of people have been named and forget about that for 10, 20 years, and all of a sudden somebody passes away and they're stuck with work that they didn't expect to have to do. The second thing to be aware of too is that you should have a backup executor or a successor trustee alternate named just in case. And if not, do you have a mechanism in place for selecting such a person if needed? Another thing to watch out for, are all of your named beneficiaries still living? And do you still want to leave them what your will or trust says that they are to receive? That's something that's very, very important. If you have minor children, have you designated legal guardians for them? Normally that's done in the will. Are any of your beneficiaries people who are disabled in a way that has them receiving SSI, supplemental security income, or Medi-Cal benefits? If so, you may want to be aware that you could disqualify them from the continued receipt of those disability benefits if you give them a direct inheritance. Better thing to use is a special needs trust that would be in place for that person. So you want to be careful about that one. Did you disinherit someone with whom you have since reconciled? That is an important reason to change your will or trust, because if you cut somebody out and now you're on great terms with them, you don't want them suddenly finding out that you had disinherited them later on. Not the thing you want to have happen. Another thing to watch out for, does your will or trust give someone a specific asset that you no longer own? That can happen a lot, especially if people decide to leave a piece of real estate to somebody and then they sell it and they don't go back and change their trust. That's something that you really want to pay attention to. And make sure you know what's going to happen if you die without a will. That's called intestacy. Intestate is a Latin term that basically means dying without a will. You don't get to decide who's going to inherit from you if you go that route. I'm currently probating an estate for somebody who didn't do a will. She didn't have any husband or kids or living parents. So we're going up through the family tree and going out to cousins and first and second and third cousins. Probably not the people she would have left things to. And interestingly enough, I've got another law firm who's beating the bushes trying to find heirs for this person, and they've come up with an additional 40 names of people beyond the ones that I was told. So, it's going to be interesting how that works out. If you don't have a will or a trust, you are leaving things to chance. You're counting on the state of California to decide who's going to inherit from you. And usually it's going to be the nearest living relatives, even if you can't stand those people. So if you have only a will, or you don't have any will at all, probate is a distinct possibility. What's probate? Well, that's a legal proceeding that occurs when a person dies, And it involves the courts. It involves about a year or more in terms of the time it takes. There's a lot of delays. You won't have your beneficiaries get access to the assets until nearly the end of the probate process. And there are a lot of hassles and added expense involved in probate. If you have interesting questions about probate, I'm happy to field those later on. At this point, one of the questions I got was, am I going to cover living trusts versus wills and other options? Yes, yeah, we're going to go into more detail about some of the other options too. But yeah, we're covering that. And at this point, I'm going to shift gears and talk about living trusts in more detail. If you have a living trust, I'm going to ask you, is your living trust properly funded, or does it need updating? Those of you who have the handout, page 9 of the handout is my checklist for existing revocable living trusts, the kinds of things that people typically let fall through the cracks, let's say. And if you have a trust, make sure that it's properly funded. You should be holding title to your assets as trustee of your trust, not just in your own name. Some assets don't need to go into a trust, things like individual retirement accounts or life insurance or annuities or anything that has designated beneficiaries with the kind of contractual obligation that the financial institution is going to have to pay to those beneficiaries, not to your trust. So those normally don't go into the trust, but your other assets, your houses, your bank accounts, your investments, businesses, those are the types of things you want to make sure you've got in your trust if you have one. If you and your spouse have what is referred to as an AB trust, that's a trust that splits into 2 trusts at the first spouse's death. And that's done normally to minimize estate taxes. But the laws regarding estate taxes have changed so much over the years. The estate tax exemption amount right now at the federal level is $11,580,000 for this year. That's a lot of money. That's a lot more than I've got, a lot more than most of you have. And that's the kind of thing that eliminates the need for that kind of complexity in a trust where it would have to be split into 2 compartments at the first death. If you have a trust that says something like it divides into a marital or a bypass trust or an exemption trust or a residual trust, something like that, that's a clue that you probably have some kind of an AB trust. You may want to have your lawyer take a look at that and re-examine whether you really need that or not. It can impose a lot of extra hassle, expense, and burdensomeness, shall we say, for the surviving spouse otherwise. And also, if you have a living trust, have any of your successor trustees or your trust beneficiaries died? Do you have a contingency plan in place for that possibility? Or will there be complications if somebody's not there anymore? Do you have a backup successor trustee just in case the first one you named is unable to act? That's very important to have. Don't just assume that the first person you've named is the only one who will ever have to serve. There may even need to be provisions in your trust allowing the beneficiaries to select a replacement trustee if there's nobody left. I had that happen recently. So glad we put that in there. The third thing on my outline is, are your beneficiary designations current? This is so very important. And what we're talking about here are assets like life insurance or individual retirement accounts, other tax-deferred retirement accounts, annuities, even US savings bonds allow you to designate beneficiaries. If you have assets like that, do you know who your designated beneficiaries are? Are those people still alive? Have you named contingent beneficiaries in case the primary beneficiary didn't survive you? And are your contingent beneficiaries still alive? I remember one of my early clients, an elderly gentleman, meeting with me, and I was asking him about assets, and he happened to mention he had a couple of life insurance policies. I thought that was interesting because he didn't have a spouse or kids. And I thought, wow, that's interesting. Who are your beneficiaries? He didn't know. He had to go home and check. When he came in the next time, he was sheepish about looking me in the eye, and he said, you know, I did what you told me to do. I checked on my designated beneficiaries, and I'm ashamed to admit that my designated beneficiary is my mom, who passed away 10 years ago, and there were no contingent beneficiaries. So fortunately, we caught that in time, and we were able to get it updated for him. But that's the kind of thing that can happen very easily if you're not paying attention. Another thing to watch out for is whether your designated beneficiaries are minor children. A minor in California is anyone under 18. Sometimes I think it's better to restrict access to funds to a later age. Having raised 2 kids myself, I know that there's a lot of maturation that goes on between 18 and say 23 or 25, that area. And you might want to use trusts to delay the outright distribution to a younger beneficiary and yet still allow access to their funds for things like college education or healthcare needs. And you know, you might want to consider guarding against some of the problematic situations that can come up with beneficiaries. You know, if you've got a beneficiary who's maybe having trouble with drugs or alcohol or bankruptcy or gambling or who knows what. On page 8 of my handout, I've got some suggested language that will give your successor trustee the option of delaying an outright distribution to a beneficiary if that person's personal circumstances at the time might be problematic. I had a situation come up years ago where an elderly gentleman passed away and he left his estate to his 2 sons, one of whom was, you know, a successful guy who unfortunately was in the middle of a divorce. And it turned out that half of his inherited funds ended up being part of the divorce settlement because there was nothing keeping it separate from the spouse. And the other son in that particular case was a beach bum who had a fondness for alcohol. He basically invested his inheritance in booze and drank himself to death. In neither case was the outcome what Dad wanted. He thought he was doing something good for his kids, but you want to watch out for those problem situations. Another thing to be very careful about avoiding, do not name your estate as the beneficiary on anything. You might think that that's a very efficient way of doing it, but what you've just done by naming the estate as the designated beneficiary, you've taken a non-probate asset and forced it to go through probate, because the only way your estate is going to be defined and documented is by the court issuing an order confirming that. So please don't name your estate as a beneficiary. Name individuals or charities. And speaking of charities, if you are leaving a gift to charity through your will or your trust, I want to ask, have you considered instead naming the charity as a designated beneficiary on a tax-deferred annuity or an IRA or other tax-deferred retirement account? Why do I say that? Because if a charity is the named beneficiary on a taxable asset, they are tax exempt. So, you know, Monterey Public Library is a good example of that. You know, if you want to do something nice for the library, consider naming them as a designated beneficiary on an IRA or any other tax-deferred retirement account, or even life insurance if you don't have any other people you want to leave your life insurance to. That would be a great use of it. And then ultimately, if you have named your spouse as your designated beneficiary, but your spouse is now deceased, have you updated your beneficiary designation since then? You need to make sure that that's updated. So beneficiary designations are a very, very important component of your estate planning and should not be overlooked, even if you have a will or a trust, okay? So I'm going to shift gears and go to how property titling will affect your plan of distribution. Many people take title to things, if they have a spouse or significant other, as joint tenants, because there is an implied right of survivorship. You may have heard the term joint tenancy with right of survivorship, and that's what it means. It means that the surviving joint tenant gets to own the thing entirely. And that works really well to avoid probate at the first joint tenant's death. But it doesn't work so well when you don't have another joint tenant to leave things to. So once you've got a joint tenancy asset like that, if the other joint tenant has died, you want to get that retitled in your name as ideally as trustee of your trust. And if you want to be careful about doing joint tenancy anyway, because for example, with bank accounts, any asset that you co-own with another person is potentially subject to that person's creditors. So, if your joint signer on the bank account has a traffic accident and gets sued for $1 million, your account that has their name on it could potentially be tapped as settlement proceeds. So watch out for that. The other thing too, if someone's a joint signer on your assets, that other person could legally withdraw your assets without your knowledge or permission. There may even be negative tax implications resulting from adding somebody as a joint tenant. What people don't realize is that if you add someone as a joint tenant on real estate for the purpose of avoiding probate, you have made a taxable gift of half the value of that property. You need to have it appraised. You need to file a gift tax return. So it's not as simple as you might think. So be careful about that. I've had so many people who structure accounts with one of their children as a co-signer on that, with the expectation that that one child is going to share those funds with their siblings after the parent dies. That doesn't always happen, and there's no legal obligation for them to do that. Once they've been named as a joint signer on an account, that account will become theirs, and theirs alone if the original owner dies. Even if they do carry out your wishes and share the money with their siblings, they might be in the position of making a taxable gift if the value of the transferred funds is high enough. So that's something that you really want to be careful about. You don't want to take too many chances with that. Get good advice first. If you are looking for an easy and convenient way to transfer assets at your death without having it go through a will or trust, you might want to consider setting up accounts with an ITF designation. That stands for in trust for, and then designate the person you want it to go to. That way they will receive it upon your death. There's also pay on death or transfer on death beneficiary designations that work the same way. And a lot of banks and brokerage firms have these available now. That's a much better alternative to joint tenants, in my humble opinion. Your banks and brokerage firms are allowing such designations, but they're not necessarily all doing it the same way. So ask your banker or broker. Also, getting into your designated executor or successor trustee, do they know what to do and where to find your important papers when the time comes? On page 7 of the handout, I've listed some questions that you should answer for your successor, trustee, or executor. And I want you to look at that list with your situation in mind. If there are questions there that apply to you, but your successor, trustee, or executor does not know the answers, now's a very good time to bring them up to speed on this. Likewise, if you yourself have been named as someone else's successor, trustee, or executor, take a look at that list with the other person in mind and ask yourself, are there any things here that I need to know more about? I think that'll do you a real big service if you can implement that. If you are designated, just make sure that you're as thoroughly informed as you can be. Know where the other person keeps their will or their trust documents. If they have a safe deposit box, what bank is it at, where to find a key, things like that. Moving to a different topic here, I want to talk about the durable power of attorney. Well, actually, you know what? I'm going to stop here for a second. I see that 9 callers have raised their hands, so I want to see what we can do to tap into some of the questions that people have been asking. And let's see. Okay. I can't see you, so I can't see the questions. Let's see here. Okay. Well, I'll tell you what, I can see that the Q&A part is working, and I've answered a couple of questions there, and so has Mary Jane and Francesca. That's probably the best thing for me to get your questions on. So use the Q&A, type in your question, and I'll try to periodically shift my gaze over to that. Okay, I'm going to talk about durable powers of attorney for a few minutes. Those are documents that basically are designed to address the possibility of your physical or mental incapacity or possible absence from the country. Our military folks use these all the time. They had their Judge Advocate General office prepare durable powers of attorney for the spouse who's going overseas, so that the spouse who's staying home has the ability to act for both of them. And that's a useful tool to have. You know, think about it. In the event of your incapacity, for example, who's going to take care of things for you? And what do you have in place to cover that? If you have a durable power of attorney, does your agent know that you've named him or her as your agent? Have you given them sufficient instruction to prepare them to manage your affairs? If your durable power of attorney has the word springing in it, it basically doesn't become effective unless and until you become incapacitated. I'm personally not fond of those, even though that seems to be the general direction that people often like to go. What I've discovered is that it's not necessarily that definitively easy to determine when somebody has actually become incapacitated. You've probably heard about people who are doing fine in the morning, and by the evening they've got what they call sundowner syndrome, where they're not functioning as well as they should be mentally. At what point in time have they finally crossed over the line into incapacity? I don't know. If you have a gradual mental decline, that's another issue. You know, sometimes you may think you're fine and other people are thinking you're losing it. It's probably better, in my opinion, to go ahead and make a power of attorney effective immediately, but make sure that you are naming the person who is right for the job. You want to make sure you've got somebody you can trust completely, not somebody who's going to abuse their discretion. And if you do have a durable power of attorney, take a look at it. Is your designated agent still living? Do you have an alternate agent named? Are your designated agents still the right people for the job, or have they moved out of the area and lost touch with you? This is all stuff you should be taking time to look at carefully. There's one other thing I need to bring to your attention. If you have an attorney drafted durable power of attorney, you may need to get a separate form done at your bank if you want your agent to be able to sign on your bank account, because the banks generally have their own separate power of attorney forms that they want you to complete in order for your agent to have signing authority. And they'll want a signature card with both of your signatures on it. So pay attention to that too. Remember too that there is no post-death authority given under a power of attorney when the person who created it dies. That's the end of the power of attorney. It doesn't allow you as an agent to handle anything after the death of the individual. So be aware of that. There's no post-mortem authority. A different type of power of attorney is the Advanced Healthcare Directive, or what it used to be called the Durable Power of Attorney for Healthcare Decisions. The old versions of that, if you have an old one that was done prior to 1992, take a look at that, because prior to 92, they all had built-in 7-year expiration dates. So you may be sitting there with a form that's been expired for a long time. Since July 1st of 2000, we now have the Advanced Healthcare Directive, which is the standard form in California, although the unexpired durable powers of attorney for healthcare are still valid. The newer Advanced Healthcare Directive is a much better form. It covers a lot more ground, and I think it's probably the better thing to have. If you have one of these, are the people that you named as your agent and your alternate agents still the best people for the job? And a really big question I ask all the time, does the document include contact information for your agents? I don't know about you if you happen to work for a hospital or other healthcare provider, but I don't think you're going to be spending a lot of time trying to look up phone numbers for people where they're not listed. You have no idea where these people live or even what part of the country they might belong to. If there's no contact information in the document for the agents, you need to add that. It's really important. And make sure that those addresses and phone numbers are current. I have seen so many healthcare directives where as soon as I go through it and ask people what's changed, almost immediately we've got new phone numbers, new addresses for their agents. So please take a look at that. It's an important thing to make sure you got right. And do each of your agents have a copy of your healthcare directive? That's an important thing for them. If you haven't given them a copy, you should, and then give them a chance to ask you any questions they have about what you really want or don't want by the way of health, by way of healthcare providing. And does your doctor have a copy? That's an important thing too. If your doctor is the one who might admit you to a hospital, the hospital by federal law is required to ask if you have a healthcare directive. And if you say yes, they're going to want a copy as part of the admissions process. So it really speeds things up if your doctor does have a copy, and that'll expedite the admission process. So I do want to recommend that if you have made arrangements for your burial or for cremation, make sure your agents know about that, because they're the ones who legally are obligated to take care of that if something happens to you. And do they know where to find your contract for the mortuary or for the cremation service or any other papers that you have? Make sure that that's something that they're aware of. You should also have in your purse or wallet a list of who to call in case of emergency. And cell phones these days have an ICE, which is in case of emergency contact that you can enter. And I think that's a really good idea. I strongly encourage you to do that. There's a new form out as of a few years ago called the POLST form, P-O-L-S-T. What does that stand for? That's the Physician Orders for Life-Sustaining Treatment. That effectively allows you to specify whether you want CPR, cardiopulmonary resuscitation, or a DNR, do not resuscitate order in place. And the physician has to sign that as well and make sure that your wishes are followed. It also addresses things like tube feeding and other kinds of care. And if you have an emergency medical services pre-hospital DNR, or do not resuscitate form, or a POLST form, you should have a copy on your refrigerator. I know that that's not an attractive thing to put up there with your, grandkids' drawings and photos and stuff. But if you're ever visited by emergency medical personnel, that is the first place that they are trained to look for any instructions regarding DNRs. So it's a good idea to have that on your refrigerator, even if it's not very attractive. So let's see here. Next topic. Are you making gifts to your family, to friends, to charity? An update for you is that the annual limit for tax-free gifts to individuals is now $15,000 per person per year. What that means is that the total of the gifts that you make to any one person in any one calendar year, if it exceeds that amount, you are going to be making a taxable gift, and it will require the filing of a gift tax return. Normally, there's no actual taxes due because of the federal exemption from taxes, but you still have to comply with the filing requirement. Remember too that when you give an appreciated asset, like if you want to give 100 shares of Apple stock to your son or daughter or something like that, when you do that, you are giving them the asset with your original cost basis. In other words, what you paid for it. So if it's gone up in value over the years, they are the ones who are going to be responsible for paying a capital gain tax if that particular asset is sold. And many people, opt to name their child or someone else as a joint tenant with right of survivorship on a deed for real estate in order to avoid probate. And they don't realize that they've made a taxable gift, like I mentioned earlier. There are other complications with co-ownership of real estate too. You get into things like who's going to pay the property taxes and the insurance on the property. If there's rental income, who's entitled to get that? If there's maintenance or repairs needed, who pays for that? Some things to talk about before you decide to add somebody as a joint tenant on anything, because that addition is a taxable gift. Do you normally make cash gifts to your favorite charities? If you do, good for you, and I applaud that. And I just want to plant a little seed here that you might want to consider donating appreciated securities like stocks or mutual funds instead of a cash gift, if you have such assets. Why? Well, by donating something that has gone up in value since you first acquired it, you are donating the capital gains as well. And since the charity is tax exempt, they won't pay any taxes when they sell it. So that's a planning strategy that a lot of people just don't realize. You get a full value charitable deduction for the full fair market value of whatever you've donated that was appreciated, but nobody is going to be paying the tax on the capital gain. And you can use your cash for something else. So think about that. Um, you can always donate appreciated securities to the Monterey Public Library, for example. There's no limit. This is one exception to what I was telling you about the $15,000 per person per year. There's no limit on gift funds that you pay directly to an educational institution for another person's tuition. Not room and board, not books, not other expenses, but tuition, okay? So if you're supporting a grandchild, for example, and helping them through college, you can actually give $15,000 plus their tuition without having made a taxable gift. But you have to make the tuition payment directly to the school. So just be aware of that. Also, there's an exception too for paying for another person's healthcare needs or medical expenses, as long as you pay those directly to the doctor or medical provider. So that's something to talk to your accountant about if you're interested in that. Shifting gears again, if your spouse has died, have your assets been properly retitled? What am I talking about? Well, let's say you and your spouse had some assets that you held in joint tenancy. Well, those need to be retitled in the name of the surviving spouse. Real property requires the recording of an affidavit of death of joint tenant with the county recorder in the county where the property is located. There's some other forms required as well for California real estate, but that's something you don't need to know right now. If you have joint tenancy bank and investment accounts, those should be retitled in the surviving spouse's name using the survivor's social security number if they had previously been under the decedent's social security number. If you have trust assets, those should be retitled in the name of the surviving spouse as trustee, or whomever the successor trustee, if it's not the surviving spouse. If you have an AB trust, for example, the kind of thing that you may not need anymore, then those assets further have to be retitled into the subtrusts. And the irrevocable trust portion has to have its own tax ID number and file annual federal and state tax returns in addition to the surviving spouse's personal income tax returns. So it's complicated. You should note also that the surviving spouse may need to update his or her durable power of attorney, especially if the deceased person was the agent, or the advanced healthcare directive, or their will and beneficiary designations. So all of that is something that needs to be attended to. You can't just assume everything's going to continue on as it did. What about estate taxes? That's an area that has changed a lot over the years. When I first started as an attorney over 30 years ago, the estate tax exemption was only $200,000. That's how much anybody could leave to their heirs without estate taxes. It's been changing gradually over the years, and now we are all the way up to where it's $11,580,000 that you can leave to your heirs. And for spouses, you get to double that number because each spouse has an $11.58 million exemption. And that will continue to be adjusted for inflation in future years. So lots of you who may have done some very serious estate tax planning years ago may find yourselves in a situation where you've got way more in place than you need or want. So you might want to take a look at your situation and talk to your attorney and see if maybe it's time to update things. Another issue that comes up for some folks, not everybody, is if you own a business, what happens to it upon your death or your disability for that matter? Do you have a buy-sell agreement with someone who can buy out your heirs and take over the business? Or do you have some other plan that's going to allow your business to continue in the event of your death or disability? Should you have life insurance to fund a buy-sell agreement? That's an excellent way of doing it. Or is the business going to just end with you? Or are you one of those people who are, if you're out of it, that's the end of the whole program, and nobody else is going to be able to take over for you? That's okay, but you know, if that's not what you want, you should be thinking about business continuation and how to do that. If you've got a family member who works in the business, that's really important because you want to make sure you've arranged for that person to inherit the business if that's what they're going to be doing, if they're going to keep going with it. And you also have to look at how is that going to affect your other beneficiaries. If the business is the single largest asset and one child is involved in the business and another child is not involved in the business, how are you going to equalize things in terms of making distributions fair? That's something to think about and plan for. Don't leave it to chance. If you have a business that has debts, how are they going to get paid off at your death? That's an important thing to plan for. Okay, I'm going to shift gears again. If you have pets, what do you need to do to make provisions for them? Well, that's a big topic. And there are multiple approaches that can be taken to provide for your pets in the event of your death or incapacity, but you should really do something about that. Legally, you cannot leave a cash gift directly to a pet, but there are a lot of other options you can consider. Our beloved Monterey County SPCA has a pet profile form on their website that I strongly recommend you look for and download and use. It allows you to spell out the specifics about your pet in terms of, you know, dietary restrictions or preferences, any medications that they're on, who the veterinarian is, you know, what their habits are, anything that's special that needs to be communicated about your pet. You're the one who knows, and you're the one who needs to tell people. The SPCA has a guardian angel program where they will take care of your pets for you if there's no one else to leave them to. You might want to look into that. I recommend too that you add a note to your wallet or purse that says that you have pets at home that need care, if that's the case. You might even want to do a limited power of attorney that authorizes the designation of a pet sitter or guardian and addresses the specifics that you want them to follow. You may want to add a statement in your general durable power of attorney that says something like, I hereby appoint so-and-so to care for any animals I have in the event of my incapacity and to follow such instructions as I have prepared, to access my account and then leave the specifics for your account if you want to have funding available to your guardian, and expend funds as needed for the care, safety, and maintenance of my animals, and to place my pets with temporary or permanent guardians if appropriate. That's just a suggestion there. Or you can leave a provision in your will or trust that specifies that the persons with whom your pets should be placed in the event of your death, and that authorizes the distribution of a cash gift to such person to cover the cost of food, grooming, vet care, and so forth. In the outline, I gave a sample of the language that you could consider including in your will or trust. And sometimes what I've done is given the trustee the full discretion to determine the amount and timing of any cash distributions. You can set a limit for that or not, do it whatever way you want. It's also possible in California now to prepare a pet trust, either as a separate document or as a component of your revocable living trust. You know, the trustee of your pet trust should be an animal lover, but they don't necessarily have to be the designated guardian for your pets. So that's a possibility too. And there's also a pet protection agreement that you could pursue, and I put a website reference for that in my handout. How much to leave for your pets? Well, that depends on the total number of pets, the type of animals you have, the pet's age, health, life expectancy. You may want to specify an upper limit on how much money to allocate for pet food, grooming, medications, veterinary care, boarding, kennel fees, toys, any compensation for the pet guardian. All of those things are something to think about. And make sure that your neighbors and relatives know how many pets you have and the contact information for anyone that you want as an emergency guardian for your pets in the event that you're suddenly incapacitated. That's something to take good care of planning for and anticipating the need. Okay, that covers my prepared comments. And so now I'm going to shift over and open it up for questions and answers. So I don't know how we want to handle that. I've got some typed questions here in the Q&A. That's pretty much covered. Yeah, those are covered. So,
her will or in her trust?
Well, you definitely want to name beneficiaries in your, if you have a living trust, name them in your trust. The will, if you have a living trust, normally is what they refer to as a pour over will. In other words, it pours over into your trust upon death so that it leaves any assets to the trust that weren't already titled in the name of the trust. I don't like to have people count on that as a guideline that will work in any event, because there's an upper limit to how much you can have transfer through the will and not trigger a probate. Essentially, if the total value of your assets passing by will is more than $166,250, that's the current number, that's the benchmark that will trigger a probate. So if you're trying to leave assets through your will to your trust, just stay under that number. Now, in terms of naming beneficiaries, a lot of it depends on whether the individual assets that you hold allow for designated beneficiaries. You may recall I talked about life insurance, annuities, individual retirement accounts, other tax-deferred pension money, whatever. Those things do allow you to designate beneficiaries. Those designations are contractual with the financial institution. So they are legally bound to honor those beneficiary designations. And that operates independently of your will or trust. So if you say that person A is going to be the beneficiary on your life insurance, but then in your will or trust, you left your life insurance to person B, I'm sorry, but the will or trust in that case won't control it. The designated beneficiary on the life insurance will control who gets it. Hope that helps. More questions?
Yeah, and a related question, how does one update or amend an existing trust?
Excellent question. How does one update or amend an existing trust? Well, if you've gone to your attorney, that's the route I would recommend, because your attorney will know the ins and outs of how to do it and what to watch out for. And most revocable living trusts are amendable. They can be changed. So it's really worth spending the time and money, if you need to get it updated, because you want that to be done right.
Another attendee asks, if I do not have real estate, do I still need to establish a living trust for my stock brokerage, CD, and checking and savings accounts?
That's a very good question. If you are able to structure beneficiary designations on those types of assets, remember I talked about transfer on death or pay on death type designations. Those allow you to specify who the beneficiary will be on those particular assets. But again, that's a less than perfect solution, because generally most financial institutions don't have it set up for you to name both primary and contingent or secondary beneficiaries on things. So if the person you named as your primary beneficiary doesn't survive you, then what happens? You know, if you have a trust, normally you're addressing those kinds of possibilities in the trust, so that you do have contingency plans built in. But it is possible to set it up that way without having to do a living trust and without having to have assets go through probate. So that's a good question.
Let me see. There's an attendee who asked for a recommendation for a good estate attorney around Walnut Creek. And I'll just share from my own history as a fundraiser that we would often have a list. We couldn't recommend anyone in particular, but we had a fairly long list of people that we, on behalf of the charity with whom I worked, knew were qualified and responsive, and we'd had experience with them. But what would you suggest for that individual?
In a case like that, I don't particularly know anybody myself in Walnut Creek that I would recommend, but you might want to contact the Contra Costa County Bar Association and ask them who is a certified specialist in estate planning, trust, and probate law. That's a specialty that the state bar has allowed us to apply for. I'm a certified specialist myself. It requires extra continuing education requirements. You have to be recommended by people, and you have to take and pass a second bar exam just in the area of specialization. So if you look for somebody who is a certified specialist, you're reasonably assured that you're getting somebody who really knows their stuff, and you're not getting somebody who's trying to be a general practitioner attorney.
Several attendees have asked about fees and about how long creating various documents and instruments might take. And I'll just read a few of the questions to see if you can respond. One individual says, what should a normal fee be to get your estate planning updated? Another individual, how long does it take to establish a living trust, will, PDA, and property transfer, etc.? Also related, what are the estimated costs associated with each option? Ballpark is fine.
Yeah, those are all good questions. And, you know, because I like to be a good consumer myself, I think it's always prudent to explore that early on in any dialogue you have with an attorney. Ask what their hourly billing rate is. Ask what their normal turnaround time would be for preparing a living trust. Let me just talk about that for a minute. When you do a living trust, normally it's a package of documents. The revocable living trust is the primary estate planning tool, but then you also have, along with it, a very simple will, what we call a pour-over will, a durable power of attorney, an advanced healthcare directive, a certification of trust, which is something that you would use with banks and brokerage firms, and more of them are requiring those these days, and a deed to transfer your primary residence or personal real estate to the trust. Those are the typical kinds of things that are included in a package of trust documents. The time on that can vary a great deal. You know, I've seen it take anywhere from a few weeks to a few years. Just depends on how quickly the client gets back to you after you've done draft copies of the documents. But that's something that can be done. Well, let me see the other. Yeah, always check to find out, if you're having things updated, is that going to be a flat fee charge, or is that going to be an hourly billing rate? And then ask for an estimate of the amount of time that they're thinking it'll take. Whenever I do updates for people on drafting that other attorneys have done, I usually just charge by the hour for the time I spend on it. And normally I can give them an estimate of the probable time that it would take to do that. I think most of the other estate planning attorneys around here do the same kind of thing. You may, in terms of cost for getting a trust done, that's all over the board. Some people charge an awful lot of money for that. Other people don't. It could be anywhere from a couple thousand to several $1,000s to get a trust package done. And as far as updating things, that's normally done on an hourly basis for the actual time it would take.
Eric, what about special needs trusts? If you're an individual who would like to pursue creating one of those, what kind of specialties do you look for in a planning professional?
You definitely want to find somebody who has experience in drafting and administering special needs trusts. They're a bit complicated, and it's an area of specialization that there isn't a certification for, but you can easily ask any attorney, have you had experience drafting and administering special needs trusts for your clients? It's a really good tool. And anybody who has a beneficiary who's on disability of any kind, unless it's SSDI, that there's no income or asset restrictions on SSDI, but SSI and Medi-Cal both have restrictions on how much you can own and how much income you can have in order to continue to be qualified for those benefits. So a special needs trust is designed to supplement the benefits in a way that won't disqualify the individual from the benefits. I really think special needs trusts are a wonderful tool. I've done quite a few myself, and I think they work really well for clients who have beneficiaries with special needs.
Back to the questions about the costs of making arrangements. Here's a kind of a twist on that. Can a client help reduce overall expenses of creating their, say, a revocable trust if they've done their homework and have gotten that NOLO press book and filled out the paperwork in advance before coming to see you?
I would say yes. The better informed a client is, the less work I have to do, because they understand what they're doing, why they're doing it, and how it's going to work. So I think NOLO Press is a wonderful resource for self-help books, and they do some marvelous and current and very helpful guides for all kinds of things. They even have one on special needs trusts. It's quite good.
How do you work with your clients under current COVID-19 strictures?
Great
One
question.
person asks, yep.
Yeah. Well, it depends on the comfort level of the client. In some cases, I've done Zoom meetings just like we're doing right now, and getting going on things without ever actually having a sit-down meeting with the client. We can do it over the computer, and there's an awful lot that can be done by telephone, email, fax, and correspondence. I actually have clients all up and down the state, some of whom I've never met. So it's very possible to do that, especially in today's day and age with all the wonderful tools we have available. I do take client appointments in the office. and we use all of the precautions that are recommended as far as masking up and sanitizing surfaces and anything that anybody touches, and making sure that we take people's temperatures when they come in, and all that good stuff. And biggest thing is to make sure that we stay healthy so that we're not giving anybody else anything. So yeah, there are still ways of getting together and getting things done. I'm not meeting with as many people as I normally did when we didn't have COVID, but that's okay. We're still getting an awful lot of work done for people, and there's so much that we can do without having to be face to face.
Do we have time for a couple more questions? Eric? Yep.
Yeah.
Okay. I'll just say before we take another question that, attendees may have seen that Inga just wrote a note letting everyone know that NOLO press titles are available at the library.
They are. Yeah.
I
think a number of the things that I've recommended in my outline are available in the library. So yeah. And I should mention too that, you know, locally, I'll put a plug in for legal services for seniors. They're over in Seaside, and they provide help to seniors age 60 and up who are Monterey County residents. And the services are free, although they're welcoming tax deductible contributions. They don't do living trusts though. But if you're just looking for a healthcare directive or a power of attorney or something like that, or if you just have an issue with your neighbor about a tree that they're wanting to cut down or something, you know, legal services for seniors can be a huge help.
It's good to know. Here's one. For stocks, bonds, real estate, can you have a spouse as a primary and a charity as a secondary beneficiary? Or should the trust be the secondary beneficiary?
Well, if you've got stocks, bonds, or that sort of thing, it depends on the financial institution whether they will allow you to designate primary and secondary beneficiaries. That's their call. It's a good idea to ask about that, and I would strongly recommend doing what you just proposed. Yeah, have the spouse first, charity second. Certainly you can do that on any kind of tax-deferred retirement account or life insurance or anything like that, and I would recommend it.
Switching gears, has the AB trust been replaced by an updated style of approaching trusts?
Well, in most cases, the AB trust is being replaced by just a straight probate avoidance trust. And rather than having the trust divide into sub-trusts at the first spouse's death, the trust simply continues on for the benefit of the surviving spouse with no interruption, change, or special hurdles to have to clear. There's a few things that still need to be done. And I do have checklists for people who may have lost a spouse and weren't sure what they needed to do. If that's your case, you can email me, and the library will be happy to forward that to me, and we can get you that checklist. But yeah, you need to ask the financial institution whether they will allow you to do primary and secondary. But yes, you can always name the charity as a secondary.
There's a couple of very specific questions that I'm going to, maybe we can capture and send to you in the hopes afterwards that you could address them. And I'm going to pick out the more general ones. Here's one. When I did my first advanced healthcare directive, I had attended a workshop with Shari Farr that offered a lot of input about selecting agents and alternates, an agent and alternates. That was many years ago, and I'd appreciate any input that you might have about making those designations.
Yeah, Sherry and I have done presentations together a number of times over the years, and I really respect her approach to things. Yeah, if you're looking at who to name as an agent, you want somebody who's really going to understand and appreciate your wishes in terms of what kind of care you would want if you're in a non-recovery situation. you know, if you're comatose or otherwise, you know, not likely to regain your normal functioning, who in your life is the best choice for making sure that your wishes are followed? It may not be your family members. They may have a vested interest in keeping you alive at any cost because that they can't let go of you. You know, you're just too loved. I hope, and you know, that may mean that you should be looking for a non-family member, somebody who's a friend, or you know, somebody you know well enough who knows you well enough, and make sure that your wishes are followed. I think that's the big issue there. And you cannot name your doctor as your agent in a healthcare directive. A lot of people try to do that, but that you're not allowed to do that. So just be careful. You know, there's always questions you can ask to find out what people's thinking would be in a situation. You know, if I'm hooked up to a ventilator, for example, do I want to have that keep going, or do I not want to keep that going because I can't talk to anybody with a tube in my throat? You know, there's things like that that you should have discussions about. You know, what do you want? What do you don't want? And you know, how can you plan accordingly? Who's going to be the best person to make those decisions for you?
Eric, you mentioned legal services for seniors, which sounds like a great referral. One attendee asks if there are any other alternatives for an individual for whom these paying for a trust might be impossible or burdensome. In fact, what it says is, are there grants, loans, free pro bono services? So is there anything for those who are under, did you say 60 or 65?
Not to my knowledge, but I don't know. I'm sorry. That's I wish I had a better answer than that.
Maybe legal services is a good place to start. Yeah.
Well, if you're under 60, though, they probably will decline politely. But it is possible to get a number of things available online. I do know that you can get advanced healthcare directive forms online. You can get durable powers of attorney online. You can get wills online. The California State Bar has a statutory will form available on their website that's free. And you know, if you have nothing better going for you, I would strongly encourage you to look that up and download one of those and fill it out.
Good, some places to start.
Yeah.
This one is kind of specific, but it might be able to be kind of extrapolated for others. One attendee is the executor of her mother's living trust, and she just purchased new hearing aids that cost quite a bit of money at $6,800. Would these be considered an asset, and should these be included in her trust?
I would say no. I mean, that's like saying that my eyeglasses are an asset. You know, it's a medical expense, and you know, unfortunately, I think those kinds of things lose value very quickly as soon as they're put into use. I don't think that's going to be something that you can treat as an asset. Who would pay for it?
Unless I'm overlooking something, and Inga and Francesca, if you see something, please just interrupt me. I think we caught most of the questions that aren't quite specific of you, and we'll forward those to you, and hope that we can get back to those who ask questions tomorrow.
Excellent. And for those of you who are still watching, if you yourself have questions that we didn't quite cover well enough tonight, if you want to send those by email to the library, they will turn around and forward them to me, and I will get you an answer.
Well, thank you so much, Eric. This has just been so informative. I always find you such an helpful and thoughtful advisor, and so we really appreciate having you this evening. I know you've done a number of talks before for us on different topics, and we hope to be sending out a survey to participants to see if there are other topics that they would like us to cover that have to do with financial literacy or legal sorts of information. And some people did ask, was this going to be recorded? And yes, it was recorded, and people will get a link to the recording if they want to play back the parts that were particularly rich for their situations. So again, I just want to thank you, Eric, and we look forward to inviting you back in the future.
My pleasure. Thank you, Inga. Thank you, everybody else. And I hope you all have a good evening. Stay safe out there.
Thank you.
Thanks, Eric. Take care, all.
Okay.